Hello, everyone, and welcome to the ARC's National Center on Criminal Justice and Disability webinar. Thank you all so much for joining us today. My name is Ashley Bronson, and I am the Criminal Justice Fellow here at NCCJD. Before we begin the presentation, I'd like to cover a few basics, especially for those of you who are new to WebEx. Participants are in a listen-only mode. If you need help during the presentation, you can post questions in the chat box on the side of your screen or the Q&A box. We'll be happy to help you. At the end of the session, there will be a time for questions. You can either post your questions in the Q&A section or the chat box section. If you don't want your name shared with your question, type private before you type the question. You can also email questions to nccjdinfo@thearc.org. If we don't get to your question during the presentation, we'll follow up with you afterward. This presentation is being recorded and will be posted to our website. We have one final request. You'll receive a session evaluation after the webinar. Please take 5 minutes to complete it and send it to us. This webinar is funded by the United States Department of Justice Bureau of Justice Assistance. Thank you for your participation, and thank you to our presenters, Jennifer Baird, Adam Stone, and Meghan Patton. To start off, we wanted to tell you guys a little bit about a brief informal survey that NCCJD staff recently conducted about mental health courts. So we did a survey of mental health courts in 6 states, Florida, Ohio, Texas, Illinois, New Mexico, and California. And we chose those states because they have high numbers of mental health courts. And we wanted to have as much participation as we could. We had 47 courts respond across those 6 states. The results were pretty interesting. 8 of those courts outright said that they did not serve people with IDD, that they weren't equipped to serve people with IDD. 15 courts accepted people with IDD even if they did not have a mental illness, if their only cognitive disability was IDD. 15 courts accepted people with IDD only if they had a primary mental illness diagnosis, so an Axis I diagnosis, as it was called in the DSM. And the rest of the group, so the additional about 9 courts, said that they really operate on a case-by-case basis. It depends on whether the individual can understand the groups and function within the group, etc. Only 2 of all of those 47 respondents said they had any specific programs in place for people with IDD. And with that, we will go to the first presentation, which is on the history of mental health courts. And our first presenter is Jennifer Baird. Jennifer is a licensed clinical social worker in the state of Florida. She graduated with her MSW from the New York University Silver School of Social Work, and she's been the program manager of mental health court in St. Lucie County, Florida for 2 years. Her clinical experience is in the areas of mental health, substance abuse, and crisis intervention. And with that, Jennifer, if you wouldn't mind putting your camera on, I will turn it over to you.
Okay, thank you so much for allowing me to speak with you today. So I am going to be talking a little bit about the history of mental health courts. So I'm going to go to an overview of what mental health courts are, and then go into history and then the mental health court that I work for in the county that I work for. So to start out, what are mental health courts? Mental health courts are problem-solving initiatives, so they differ greatly from traditional courts and how you would expect when you go into a traditional courtroom. And what they mean by problem-solving is that we seek to address the root causes that contribute to criminal involvement. That means, what are the issues that have led that participant to be involved with the criminal justice system? And then not only do we look at what causes it, but then how can we help? So what we do with mental health courts, and as you know, we focus on those with mental illness and those with intellectual disabilities. So I'll go into the whole process as we move on in the training, but the primary focus for mental health courts is, again, seeking to identify those causes and then how can we help those participants. So just a brief history on mental health courts. They were started in 1999 in Broward County, Florida. That was the first recognized mental health court, and it was developed in conjunction with the judge and the community as a response to jail overcrowding, critical problems faced by mentally ill inmates, what people who have worked in the system have found is that those who are incarcerated with mental illness often decompensate severely when they're incarcerated. It increases paranoia, and then it also, when people are facing detoxing and going through withdrawals in the jail, it creates a unique set of problems for those inmates. And then also, that leads me to the next one, there's a high prevalence of inmates with co-occurring mental health and substance use disorder, and they have a unique set of needs that aren't fully and adequately addressed in jails. So since 1997, numerous mental health courts have been started, and of those, they all look different. So each one is unique in its setup and what clients it accepts, its guidelines for accepting participants, and who all can participate. So what I'm going to do is going to go with what I know, which is the St. Lucie County Mental Health Court, and I'm going to talk to you about how ours is set up. So ours was started in 2006 with 6 participants. We are now up to 183 participants, and that varies week by week as clients come in and then clients are discharged from the program. Now, in St. Lucie County, Mental Health Court was started in connection with the community. Our judge for mental health court has been there from the beginning. Her name is Judge Cynthia Cox. She was really a strong advocate for starting mental health court because working as a judge, she saw clients coming in over and over and over again because when they were discharged from jail, what would happen is they would decompensate in jail. They would be released with a very limited supply of medications, and then they would end up getting a new charge and coming right back in the court system. So what she did is she met with the community leaders. We have a very supportive county that we work with. The jail was involved, our public defenders were involved, the state's attorney in our community were involved, and they sat down and they came up with a plan for what they can do to help solve this problem. So with that, mental health court was created. So what the goals and the objectives that they wanted to cover, but they wanted to address this revolving door of mentally ill inmates going in and out of the jail, and then of course to reduce jail crowding, and then really to focus on being rehabilitative for the mentally ill population, not just punitive. So our court, again, every court's set up differently. We accept both felonies and misdemeanors. We have a whole mental health court team that's involved with our clients. So we have our judge, we have the state's attorneys that are involved, we have our public defenders. Our county actually has an entire team, a team of 6 people that do nothing but monitor day-to-day on clients. And then we also work with community partners, community agencies as well. So how are clients considered for mental health court? What happens is they have to be diagnosed either with a mental illness or intellectual disability. So what happens when someone's referred to mental health court, our client services department of the public defenders will go through all of their history of hospitalizations, their previous psychiatric records, any previous convictions or arrests. They'll look at their current and their past mental health diagnosis to see if this person really is going to qualify for a mental health court. And then any cases involving a victim must have the victim's agreement before the case can come over to mental health court. And what we found is that our state's attorney really acts as the gatekeeper for coming into mental health court, meaning in order for someone to actually come through, all parties have to agree. So the attorney or public defender, private attorney or public defender, the state's attorney, and then the judge also has to agree in order for someone to come in. And the state's attorney really helps provide accountability for who else is coming into mental health court. So who can refer a client to mental health court? The way it works in St. Lucie County is anybody really can refer a client to mental health court. I've had family members call, I've had probation officers call. The public defenders can refer their clients as needed. The state's attorney can refer clients. Even the jail will sometimes notify our office that they have someone they believe would be a good candidate for mental health court. Either they've come in numerous times or they have a serious psychiatric condition or intellectual disability that the jail is observing. They will call us to see if they can get our assistance with that case. So, legally speaking, there are numerous different ways that a client can enter mental health court. In St. Lucie County, we accept pretty much every way. So we have a diversion, which charges are no pros. That means the charges are dropped once the program's completed. This is how the mental health court originally started as. to be a diversionary court, so people can come in, they can get the treatment that they need, they can get the help, and then when they've successfully completed the program, they won't have that criminal charge on their record. But we have kind of developed since then, and now we also accept people who are like a condition of probation. So what happens is they will have a special condition on their probation, which will be that they have to successfully complete mental health court. And the reason for that is we provide much more oversight. We're much more intensive than standard probation alone. So we help make sure those clients have doctor's appointments, and we really help support them, especially for ones who have not successfully completed probation. What will happen is when they go for their violation hearings, they will have mental health court added as a special condition to help them successfully complete probation. And then the jurisdiction for mental health court ends when probation is complete. Similar to that, we also have people come in as a condition of their release or their ROR, and then a condition of pretrial. Pretrial is a program that monitors clients from the time they're arrested until their case is heard in front of the judge. So we can assist those programs as well. And then the last type that we have is we have our forensic services. We have the NGI, which is the not guilty by reason of insanity, and the incompetent to proceed, or ITP. So they monitor people in the state hospital, and then once they're released on conditional release, which means that they're back in the community, mental health court picks up and assists with monitoring there as well. So what happens when someone's accepted into mental health court is all of the clients are assigned a court manager, and what that court manager does is it's kind of like the probation officer for mental health court. So they assess each client, and then they make the necessary referrals. So the areas that they assess, they go into psychiatric services. So does this client have a doctor? Do they need to be set up with a new doctor? Do they have their medications? Do they have a way to pay for their medications? They examine all the different aspects around their psychiatric services, and then they also monitor compliance with those psychiatric services. So they are the ones who give the updates to the court to let the judge know whether the person's actually actively participating in the program or not. They're also assessing for things like therapy. Do we need to refer the client for therapy? Do we need to refer them for substance abuse treatment? Case management's an important piece as well, so linking the person with the participant with the community and helping them and assisting them as needed. And then also we do link to community resources, such as our Agency for Persons with Disability. They work closely with our intellectually disabled population. And then we also provide peer support as well. So the goals for mental health court. So what the mental health court does is our primary focus is assisting our clients with learning how to access those existing service providers in the area. So when our clients leave the court, they know how to follow up with their medication management. They know what indigent drug programs are available, so that way they can continue to get their medications even if they don't have benefits. We work to provide them access to benefits. We have 2 case managers that work with our indigent clients who wouldn't otherwise be able to receive case management services, and we link them up with community supports. We link them up with food stamps and Social Security, and apply for insurance for them as well. So the goal another goal from mental health court is just to remove all the barriers to access for client services. So what we find in our community is that our clients encounter difficulties when they're trying to engage in different programs, either, well, usually it's funding, not having the money to pay for the services they need, and then just having difficulty accessing like unknown services or not knowing what's there. So what mental health court does is remove all of those obstacles. So we provide case management for those who couldn't otherwise afford it. We link people with case management who have insurance and can have that service provided through their insurance companies. We pay for medications as needed. We also assist with housing. So the goal is to help our clients be successful in the community and then work to get them independent so by the time they graduate, they have all these things in place and they know how to continue with those things. Another thing that mental health court really focuses on is striving to balance treatment with accountability. So mental health court, as much as we do help, and we link up to services and we provide services and monitor the treatment aspect, we do also still have to hold our clients and our participants accountable for their choices and behavior. So we have an excellent team that works together to look for those things, and as needed, we will sanction clients as appropriate, usually community service, but jail if needed, to help monitor and hold our clients accountable, but also provide treatment at the same time. So say someone has a relapse, yes, they have to be held accountable for that, but then we don't stop with accountability, we move forward to treatment. Okay, what else can we do to help this person? So another goal for the mental health court is to decrease the rate of mentally ill clients returning to jail. Again, it's that cycle that I was talking about earlier where mentally ill clients, when they go to jail, they get discharged without medications or with very little medications, and then they end up right back in jail. So our goal is to stop that cycle, and then of course, lastly, to increase community safety. So we, like I said, have a whole team of people that are dedicated to nothing but monitoring our mental health court participants, with the goal of keeping our community safe. So how can mental health court benefit clients with intellectual disabilities? The court I work for, we do have clients who are intellectually disabled. That is one of the qualifiers for coming into mental health court. And what we found to be most effective with those clients is that we work very closely with our community partners, and we work to provide that consistency that our clients need, and then also repetition. So what happens is before a mental health court, we have a staffing, and that's with the attorneys, that's with all the community partners and the judge, and we talk about the cases and talk about any needs that they have. And we all present the same message to the client. So whether they contact my team or whether they contact the Agency for Persons with Disability or whether they call the attorney, we're all giving the same exact message to the client to help with the consistency. And then repetition is really key for our intellectually disabled clients. We have our clients come weekly, especially at the beginning, and then as they do better, we can put those out. But anytime there's problems, we will get them right back onto a weekly court schedule so they can be in front of the judge and we can tell them the same thing that they need, that's needed over and over and over again until they can fully understand it. So the other thing that mental health court does to help our intellectually disabled clients is we hold agencies responsible for timely access to services, and then also the quality of services provided. So if we have any difficulties, all these agencies have representatives who come to our mental health court, and essentially they're accountable to the judge for if services haven't been accessed timely, the reason for that, and then if there's any concerns about the quality of services, if the clients have any concerns about quality of services, all of those can be brought before the judge and addressed. So we really work hard to hold all of our community partners accountable for the services that they provide. And then lastly, the thing that we really found has benefited our intellectually disabled clients is that mental health court is a much less structured court environment. So our intellectually disabled clients have as much time as they need to ask questions and to be able to talk and interact with the judge. And what we found is in a traditional court setting, the judge expects our clients to have talked to the attorneys, and they come in, it's very authoritative, and they tell the client what's going on and then done. But in mental health court, our clients actually can engage and spend time with the judge. We have some that sometimes will take half an hour in front of the judge, but usually at a minimum of 5 to 15 minutes or 5 to 10 to 15 minutes to really help them understand those expectations and requirements for the program, and then also to talk about those things like how is your service providers treating you? Are there any needs that you have that aren't being met? And so our clients are really able to better understand the system and why they're actually in the judicial system that way. So that is it for me. Thank you for allowing me to participate.
Great, thank you so much, Jennifer. I'm just going to go ahead and mute you until it comes to question time. Just stay on the line. We've gotten some questions already. If you have questions for Jennifer, please put them in the chat box or the Q&A box, and we will be doing a Q&A session at the end of all three of our presenters today. Our next presentation is by Adam Stone. Adam Stone is the founder and managing partner of Martin & Stone LLC, a small litigation firm in, I'm sorry if I butcher the name of your town, Bucyrus, Ohio. Adam practices primarily in the area of criminal defense and has done so for the past 7 years. Adam's practice deals with mostly violent crimes, drug crimes, and sex and internet offenses. It extends from state courts all across Ohio into federal courts in Ohio and Louisiana. And with that, I will turn it over to Adam, if you can just click your camera.
All right, I think I did that.
You did.
Oh, very good. All right. And the camera's recording? All right, very good. Essentially, my job today is to critique mental health courts, especially with regards to some of the practical challenges that mental health courts are dealing with. I want to make sure everybody can hear me. All right. From our standpoint, every day when we go in to work with clients, deal with them on a day-to-day basis, one of the biggest challenges that we find, first of all, is identifying people. What is the difference between someone with a mental health diagnosis and someone with a developmental disability? And there's some specialized training that comes with that most attorneys, public defenders, by their very nature, do not have. At this point, one of the things that we do, that I see, one of the biggest critiques that I see, is we have this notion when we walk through the door with a client that he or she may be suffering with a mental health issue or a developmental disability. The first most important thing that comes up is, and I think I'm moving this, I'm not sure.
Are you trying to move your slides?
Yes, I am. It's not allowing me to for some odd reason.
That's fine. Just let me know when you want to move and I'll move them.
Thank you very much.
You're welcome.
What we're finding is, in terms of identifying these people, these folks, what is the scope of your mental health court's experience with individuals with developmental disabilities? How do they define a developmental disability? Does that person have to be deemed incompetent? Do they need a guardian? And if so, who are you really trying to serve? Who is the court or the docket attempting to serve in that regard? The challenge that I find when I'm walking through the door with a client who I believe has a mental health issue or a developmental disability is the court's receptiveness. And I know this is something that I think most of our lawyers face. You walk in and you say, I believe this person may be suffering from some type of bipolar disorder. I need an evaluation. I want to see this person in the mental health court on the mental health docket. All right, well, now I have to have an individual showing of what leads me to believe that person is suffering from this developmental disability. For instance, I'm going to use one client that I've had recently who suffered from a very, very serious, very rare developmental disability called Smith-Magnuson disorder. He did not actually make it onto our local mental health docket. Now, this disorder is found in about 1 in 50,000 people, I believe, and it's essentially a disorder that is based on a biological break in the alleles of his DNA at one certain allele. This young man, because of this, he suffers from impulsivity, outbursts of violence. I mean, during a change of plea, as I'm changing his plea, at one point he actually breaks out and begins to attack our prosecuting attorney, and he goes after our magistrate. We have to physically restrain him, pull him back. And what we end up finding out is this young man who had shown no signs, up to this point, showed no signs of any real mental health issues, suffered from this very rare disorder, and was treating it with crack cocaine and alcohol. Now, I go in to the court having found this diagnosis actually through his school records. And I present this to the judge, and I'd like an expert to testify, I'd like an expert to review him. Well, because of the nature of the disorder, the court wasn't willing to give me the money necessary to actually provide the services we need. So then we go to the Board of Developmental Disabilities, and this is what you as the practitioner, and I guess I'm looking at this from the practitioner's, the attorney's standpoint. What is that mental health court's relationship like with your local Board of Developmental Disabilities? But not only that, what is your relationship like with your local Board of Developmental Disabilities? If you're going to be representing folks with IDD, you need to have that relationship. You need to know who your caseworkers are, who you can call when you have a situation like the situation that arose with this young man. And ultimately, if you're practicing out of county, get in touch with local counsel. If you're in a county where you don't exactly know what's going on with that mental health docket, get in touch with local counsel. Find someone there that can get you in touch with the local Board of Developmental Disabilities. Make the appropriate introductions so you can start making those relationships so you can serve your client best. And ultimately, we have to look at, who's managing the expectations of the providers within the mental health court. What I mean by that, as you're walking into that court, is this court really driven by a judge? I know the judge oversees it, absolutely. But is it being driven by a judge, social workers? Is it being driven by the Board of Developmental Disabilities? Who is actually in charge? The prosecuting attorney? Who is the gatekeeper to that court? And one of the things that I found interesting about Jennifer's presentation, she noted that each court is unique. And that is so true. And from a practical standpoint, because there's no uniformity in our mental health dockets in Ohio, you know what to expect walking in the door when you have that mentally ill client or you have that client with a developmental disability. You don't know what to, you as a practitioner, unless you practice in that court every day, you're not going to know. So you have to get in touch with the people who do know, and you have to be prepared to make those connections early and hold people accountable. One of my biggest criticisms of our mental health dockets, we put these folks into these courts. We provide them with the services. We might even set them up with a guardian depending on competency. But what's our follow-through? How do we, and we're going to get to how do we measure success, because I don't see any court really trying to measure success. But how do we measure success for that individual client? And as counsel, as you're sitting there, your goal is not only to defend your client, that's always number one, hold the state accountable, but ultimately making sure that that client is provided with the services that he or she needs on a day-to-day basis they wouldn't otherwise be provided. That to me is, when I see the mental health courts, I see them as that door, that gate that we open up for those people who would not be served. Give them the opportunity to be served by the community and through the resources. The nice thing about Ohio is the entire state, every county, 88 counties, we have a Board of Developmental Disabilities. So there are resources there. And I will say this much, every Board of Developmental Disabilities that I've worked with in the state of Ohio has had some resources. Some than others, absolutely some more than others. But each board has had some resources for every client I've had. Every client that I've had that I've been able to get into the mental health, onto the mental health docket with developmental disabilities, my Board of Developmental Disabilities has been able to at least provide some degree of service. You want to go ahead and move the slide? This goes to a very practical challenge, and I think I'm going to go back to my client with Smith-Magnuson disorder. My mental health court was not equipped to provide services to this young man. Absolutely not. We had a lot of well-intended people sitting at the table trying to figure out exactly what it is we should do for this young man. He was literally, he was treating a rare developmental disorder with crack cocaine and alcohol. And once we got him in and started to realize what was going on, it became this argument between the lawyers, the social workers, adult protective services. We even had children's services involved, and our local Board of Developmental Disabilities. the prosecuting attorney, the judge, to the extent that he was a lawyer involved in that argument, how we were going to serve this kid, and if we could we? And ultimately it was determined that this mental health court, this mental health docket was not made to provide services for this young man. Finally, we look at some qualifications and training. I think this is a huge, huge problem with our mental health dockets in Ohio especially. These are, again, very well-intended people, but lawyers defending people with developmental disabilities, even just mental health diagnoses, we have to have specialized training, and a lot of that training is missing. And unless you take the time to sit down and discuss these different issues with a neuropsychologist, psychologist, psychiatrist, some type of mental health professional, and begin to develop, I don't want to call it a specialization because our rules of professional conduct actually prohibit that, but if you kind of develop a certain degree of specialization in dealing with folks who have these disorders, you're running afoul. You may be looking at ineffective assistance of counsel claims, maybe even malpractice. And what are your ethical duties? If you're dealing with someone, or the court knows that you're dealing with someone who has developmental disability that you cannot handle, you cannot communicate with that client cannot communicate with you. We have, as practitioners, as lawyers, we have been in that situation where the client literally cannot speak to us, or is speaking to us in such a way that we know that they're sick, we know they need help, but we can't identify the need. And when we put people in front of that individual, we're beginning to compromise our defense, our ability to defend that person. We all know the Fifth Amendment right to remain silent is one of the tantamount in criminal defense work. But if we put them in front of a counselor, a social worker, adult protective services, what are they going to say? And to what extent does the privilege that they share, what extent does that actually hold up? Finally, again, we go to follow through. This is something big for me. I have a ton of clients in mental health, on mental health dockets and mental health courts who are working through programs, and my biggest criticism is who is ensuring that that client follows through with the services. Do I have a guardian? Do I have a caseworker with the Board of Developmental Disabilities? Do I have somebody involved in this case besides myself who is holding this young man accountable? And we would think oftentimes that the court would be the one holding the young man accountable or the young lady accountable, but too often I see, again, this is my criticism of these dockets, the court leaves it to the professionals, becomes the rallying cry, I guess, for the lackadaisical manner in which we service these folks. So ultimately, you as the practitioner, the lawyer, the social worker, even the mental health professional, you have to be ensuring that that young man or woman or old man or old woman, doesn't matter, is accountable, is absolutely accountable to the services that are being provided. Okay, we can move on to the next slide. This is actually really big for me. This is probably, for me, this is the most important thing because it kind of sums up everything that we've talked about so far. And it comes down to how do mental health courts measure their outcomes and define their success. All right, we have so many resources out there. And when we're actually trying to define success as a mental health court, what are we looking to? Are we looking to whether that individual has met the service, is taking advantage of the services to the extent necessary, and it's at what point, who's defining what is to the extent necessary? I mean, here we have this criminal justice system. I mean, if you look at 2911, or 2911, 2912, the principles and purposes of sentencing and under the Ohio Revised Code, it is a balance between the safety of the public, rehabilitation, and protection. what are the rights of the defendant and the overwhelming needs of these individuals? We are looking at folks whose developmental disabilities range from the autistic, those who we used to call it Asperger's, high functioning, to those who are committing crimes and are very low functioning, but still committing crimes. And within that criminal justice system, in Ohio especially, we have to remember that simply because you are incompetent for the purposes of a guardianship does not mean you're incompetent for the purposes of standing trial. So how do we as a criminal justice system balance those different considerations as these people come forward into these mental health dockets? How do we meet these needs? And in doing so, I think, Jennifer spoke about it, and I really like the way she put it. When we do meet the needs of the individual, when we do meet the needs of the individual suffering from a mental health diagnosis or a developmental disability, we are better ensuring the safety of the public. We are better defending the rights of the defendant, of the individual. We are actually striking that balance. But I think so often we don't actually determine what that balance is. Our mental health courts, and again, this is my own personal observation, they came on the heels of drug courts and the veterans courts. They are, at least in my experience, very politically driven. Judges, courts love to be able to say, we started a drug court, we started a veterans court, we started a mental health court. There's a lot of politics behind it. And that gets me to my last point. How do we, as lawyers, manage these relationships in such a way that it benefits our client? You have to be able to walk through that door and have those practical considerations that you're going to be sitting at the table with Adult Protective Services, the Board of Developmental Disabilities, potentially Child Protective Services, and there's going to be inner conflict. Everybody in the room is going to believe that they know what is best. And ultimately, who do we turn to? We should be able to turn to the court. But more often than not, what I'm finding in my practice is that the court turns it back over to the defense, the prosecutor, Adult Protective Services, maybe Child Protective Services, the Board of Developmental Disabilities, and it becomes this huge infight over what is best or how best to meet the needs of this individual. And do we as defense lawyers compromise maybe what could be a potential not guilty? This is an ethical consideration. We all struggle with this. You have the first duty to defend your client, right? And that is paramount to everything that we're talking about here. Defend your client. Ensure that the state can prove your client is guilty beyond a reasonable doubt. But let's take a hypothetical where they can't. You're defending that individual with a developmental disability, but they're not getting any services, and they're going down that dark path where maybe they're self-medicating with crack cocaine or alcohol. What do? Do we sacrifice the right of the defendant to the jury trial, the holding the state to find them guilty beyond a reasonable doubt as to each and every element of the offense? Do we sacrifice that to ensure that they get at least the opportunity to get some of their needs met, the opportunity to be a part of this mental health docket? What does the court require? Do they require a guilty plea in order to get those? If they do, then you may be in that struggle. You may be a part of that struggle. But ultimately, it is this, and this again, this is my own experience, it's this constant conflict. It is this tug of war as to who knows best when you walk into that mental health court. Because we have all of the, and it's a wonderful problem to have. We have these great resources out there that are all trying to do what's best for this individual, but they all want to be the solution. And I think as the lawyer, you know the client. You know the client well. You should. know the client well. You should know the client's family dynamics. You should be able to walk in that door, sit down with that prosecutor, listen as everyone talks, and manage those relationships, manage those conflicts in such a way that you find a resolution for your client that at least gets them the opportunity to take advantage of resources that they need. And I think that kind of covers for me not just the basics of my I actually got the easy job in this thing. I got to critique the mental health courts. I got to be critical of them. But it's a difficult challenge. It is absolutely a difficult challenge for any lawyer who's walking into a mental health court. You don't know what you're walking into. There is no uniformity. There's no uniformity as to what constitutes a developmental disability for the purposes of a mental health docket. What constitutes even a mental illness. I walk into a Crawford County, Ohio court, mental illness is A. I walk into Wyandotte County, which is literally 15 miles down the road, and they do not recognize that, even though your DSM-5, it's a recognized diagnosis under the DSM. And you make that argument, and a lot of times the judge says, sorry, we don't recognize that here, or we can't meet those needs here. How fair is that to the individual you're serving? And what do you do for that individual then? It becomes a very, very difficult, challenging situation. But I challenge each practitioner, every lawyer that's listening, really get to know your client. Really take the time to get to know your client. Really take the time to get to know the family dynamics. You're going to learn so much that helps you when you walk in the door to deal with all of these interests that are pulling. Any questions that anyone has, please feel free. That kind of concludes my presentation at this point.
It helps if I unmute myself when I'm speaking. Adam, you can go ahead and click your camera, and that way you're not being watched. I do know that Adam does have to leave a little bit early probably, so if for some reason you have a question specifically for him and he has to leave before we can get to it, I will pass on your questions to him so that he can follow up. The last presentation we have today is from Meghan Patton, and Meghan is currently the Mental Health and Developmental Disabilities Court Coordinator for the Cuyahoga County Common Pleas Court. This role allows her to assist the 5 MHDD judges with the direct operations of the court. Her previous positions with the court have included MHDD probation officer and pre-sentence investigator. In this capacity, Meghan was lead coordinator and co-chair for several departmental work group and committees throughout her 10 years of public service. She also served with City Year and AmeriCorps National Service. Meghan obtained her Bachelor's of Art in Political Science at Bowling Green State University. And Meghan, I will now turn it over to you.
Hi, thank you for having me. For those of you that don't know, our county is actually located in Cleveland. So we are an urban court that has a lot of cases that come through our mental health and DD court. We actually do function differently, and Adam is right. In Ohio, there are different courts that function differently, rural versus the urban. The Ohio Supreme Court has begun to try to unify it to some degree, and we are kind of in that process with them right now. Although our court was established a little bit differently than most courts in the world of mental health courts, as we accept a much larger capacity than any of the other courts around the nation probably do, and I'll go into that and explain it. I'm trying to change my slide. I don't know if I can, though.
If you like, I can just change them for you. It seems like we're having some technical difficulties with that.
Okay.
Just let me know when you want me to change them.
Okay. Okay. Are you on what is the role of the mental health court slide now?
Do you see the slide?
Yeah, it's just like the title one.
Oh, okay, hold on, give me.
Okay. So here I just have the national and local perspective, and obviously Jennifer went into this a whole lot, so I'm not going to go through a whole lot of it and explaining how the mental health courts were created, because she did a really great job in that. But I will say that the mental health people in Ohio, a lot of them are in our prison. We have over 10,500 inmates in Ohio at the beginning of this year that suffer from mental illness. 1 in 5 had a diagnosable mental illness, and 1 in 12 had a serious and persistent mental illness. And also there are 10 times as many mentally ill inmates as there are patients in our 6 hospitals. So our goal in Ohio, and especially in our court, is to continue to decrease the amount of mentally ill people that are in our jails and prisons, and to hopefully decrease the amount of time that they cycle through. You can go to the next slide. Okay, I think I am able to change it now. I just wanted to give you an overview of our actual court history. In the 80s, we had a lot of increased numbers of defendants who were having issues with mental health and DD in our court. What our probation department did was to create at that time what was called the mentally disordered offenders and the mentally retarded offenders. Obviously, we don't use that term anymore, but back in the 80s, that was the term that was used. We created units in our department to help consolidate those people in order to help triage them, have better trained people around them, and give them the services that they need. In 2002, our court partners are municipal courts, our common pleas court, community stakeholders, so that was behavioral health agency, our prosecutor's office, our public defender's office, and many, many more created what was called the Mental Health Initiative. And this group really worked on identifying the programs and services, identifying gaps, expanding where we needed to, along with creating a communication between everyone and a training, and training, which Adam talked about, is so important. Through this year-long look into how to serve the defendants who are mentally ill in the criminal justice system, what came out of that is that our common pleas court, where I work through, created the Mental Health and Developmental Disabilities Court, and we gained our knowledge through that mental health initiative. Amendments were made to our local rule, and in June 9, 2003, our court was established. Obviously, like I said, we changed the name of our unit in the probation department to better reflect the most appropriate names, and then they were changed from MDO and MRO to mental health and developmentally disabled. Presently, right now, we're really working towards, like I said, working with the Supreme Court of Ohio. They actually do have a specialized docket certification process for their drug courts, their mental health courts, their veterans courts, their treatment courts, lots of different ones, and they have a uniform way of what a court should look like. And I think over time, as more courts become involved in this, hopefully in Ohio, the differences between each court won't be as apparent. So our mission in our mental health and DD court is the mission is that we promote early identification of defendants with severe mental health and developmental disabilities in order to promote the coordination and cooperation along law enforcement, jails, community treatment providers, attorneys, courts, for the defendants during the legal process and to achieve the outcomes that both protect the society and support mental health care and disability needs. Our goals in the mental health course is always to increase the community safety for our county, improve the continuum of care that our mental health and DD defendants receive, continue and increase the collaboration with our behavioral health agencies, improve the defendants' supervision and engagement and compliance, and then also our goal that we really are working on is to also improve long-term participation in behavioral health agencies. We're really beginning to look at, hey, when they're with us, they're doing really well and they're going to their appointments and they're doing everything that they need to live a really supportive and healthy life. But what happens when the court leaves them? And how can we do things in our court that can continue that process on as they continue after the court engaged with them? These are just our local rules. If you ever needed a copy of them or to look at how our local rules are written, we could always get that online through our court website. Like I explained, we have 5 mental health and DD judges, so our common pleas court bench is 34 judges. Out of those 34 judges that are elected to our bench, 5 of them volunteer at any one time to be on the mental health court bench. We have a chair and then our other judges. And these judges really understand that they take on a time and training that they need to do and to be really involved in these defendants' life more than what they probably have experienced in the past with their regular criminal docket. Here are our eligibility requirements. And like Adam said, ours are probably different than if you did go to a county in a different place not too far from us. The reason that we have picked these diagnoses is because of our capacity issues. So for our mental health diagnosis, anyone is eligible to enter the mental health court if they have a psychotic spectrum mental illness. And these are some of the brief examples that I have. So you have to have psychosis in order to be eligible on the clinical basis for mental health. As far as our developmental disability diagnosis, I've listed all of those that we expect. And more so, we're beginning to see more autism spectrum disorder than I think we have in the past, which is very interesting. We do accept a bigger pot of eligibility than just our county board does. And that determination was made because we didn't want, even though you weren't eligible for the county board of DD, because their eligibility can be constrained and tight, difficult to meet, we still didn't want our developmentally disabled defendants lost throughout our court. A lot of times, as most of you probably know, it can be very easy for DD defendants to really skate by through the criminal justice process. They learn it's easy to say yes. They learn not to ask, or maybe not as capable as to ask as many questions as maybe somebody else that didn't have their limitations, and that's something we really wanted to make sure that we embraced, and we hopefully were able to obtain as many of those defendants as we can in order to give them a really comprehensive care when they're in our court. These are just some of our court stats. 72% of all of our mental health and DD cases that were eligible went to an MHDD court judge. Our MHDD court judges' dockets consist about 45% of their dockets are MHDD defendants at any one time. So that's their active case that's going through on pretrials, and then also their closed probation cases on their criminal dockets. 136 MHDD defendants were placed on court-supervised release during pretrial, and then 442 MHDD defendants were placed into our probation unit last year, 293 of them came directly from the MHDD court. And this is where I think in our court, our capacity level is probably greater than what you typically see across the country. We typically serve about 750 MHDD defendants in our probation department at any one time. And approximately, currently about 550 people are directly from the mental health court. Our defendants in mental health court are similar to our overall population in race. However, a higher percentage of women are in our court than may be seen throughout the court in other units. Oftentimes, our defendants struggle with chronic homelessness, unemployment, and then more often than not, they're indigent as well. So how our court differs a little bit from maybe models you've seen elsewhere is that we place a lot of importance on the mental health court early track. So that's any action from the time they've been arrested to the time they are sentenced. Our mission is to serve all defendants who may suffer from our clinical mental health eligibility. That's the slide that I went over a few back, regardless of the outcome of their case. As one of the largest urban counties in the state, our court does function differently than smaller courts, and we offer a unique approach to capturing and serving this population. And like I said, we place a high importance on early identification and make sure that during the pretrial process they have a trained mental health judge and they also have a trained attorney. All of our assigned counsel and all of our public defenders who receive cases that have a defendant that is eligible for MHDD court have to go through a training. And this is typically a day-long training where they receive training on mental illness and DD. They meet with our jail liaisons that help with us. They have a preview of what our mental health court is like. And so the good thing about that is if you're assigned counsel or if you're in the public defender's office, you know what's going on in our court and you understand when you're walking in what it's going to be like. And I think it's something that our court instituted that is really a powerful statement that we really care about the how people treat the mental health in our court and our DD folks, and how they are able to make sure that they have everything at their disposal to be successful. So that is our early track. So I'll kind of explain it a little bit different. Here's our mental health court initiative. So this is our mapping. And so what it shows, if you would go through it all, is that once they are found to be clinically eligible, so that would be through any type of recent diagnostic assessment, they would then be flagged as mental health in our court database. At arraignment, they are rolled to a mental health judge, and then they are also assigned, like I said, a trained mental health attorney. Now, that doesn't automatically mean they're going to be on a probation term. Some of our people, they could be high-level offenses, and they could, have to be going to prison. However, what our goal is to make sure that they are given appropriate people who understand our behavioral health field and how we do things in the mental health court as soon as possible. So for our local responses and our case flow entry from arrest to disposition and community control, many specialized services have been developed for our MHDD folks. We've worked with our county jail, our bonds commissioner's office, our alcohol and mental health board, lots of our behavioral health agencies, our county board of DD, our court psych clinic, and then inpatient, outpatient restoration. With our local responses to our county jail, we have incorporated mental health and DD screening questions in the booking process. There is a dedicated mental health intake specialist in the jail that refers inmates back to their mental health agency, to the psych department in our county jail, and then if they are eligible for mental health, then refers them over to our court as well. The county jail, like I said, has a medical staff. We have approximately 65 acute MHDD beds. Our alcohol and drug boards and our county board of DD, we each have a database dump that our booking list in the jail off of their lists hit off each other and produce a list of names. And those helps identify who's in the jail, who is mentally ill, who is DD, who needs to be seen by this psych clinic, who needs to be flagged and enrolled to a mental health judge, and if needed, who gets an assigned attorney. One of the great things that we have in our county jail is our forensic jail liaisons. We have 5 of them from 5 different behavioral health agencies, and these are our people that are in the jail day to day, finding their people or people that need to see that could be MHDD in our court, helping with release plan, getting the person back to linkage, working closely with the MHDD judge on recommendations, and then obviously our treatment team staff as well. The bond office, when they go in and interview the defendants in the jail, they have mental health screening questions that are also in their interview process. If they answer yes to any of those questions, then the bond referral goes over to the jail liaison, so then they can look more into it. At arraignment, obviously, like I said before, if the defendant is found to be eligible for MHDD court, that case is flagged through our probation coordinator, and then that case is rolled to one of our 5 mental health judges at a random roll and assigned an MHDD attorney. Typically, we review about 1,000 cases per year for clinical eligibility. So far in our case management, we have 5,101 cases that have been flagged as mental health and DD since our flagging began, I think, about 2005. So once you get through the pretrial and you're able, and you're now legally eligible, and you're at this sentencing phase, you can then be possibly granted a community control sanction at the discretion of the MHDD court judge that presides over that case. So our legal eligibility is any felony or pled down misdemeanor level, plea of guilty, judicial release status, defendants eligible for any type of diversion could also come through to the MHDD unit. We allow all risk scores, so we use the Ohio Risk Assessment, so they're risk to recidivate, and we take in low to very high. Obviously, once they are in our MHDD unit, we obviously triage them differently based on their risk score. Exclusions are the NGRIs, or the incompetent to stand trials. These cases during the pretrial process are able to be assigned and enrolled to an MHDD court judge. That judge may have more intimate knowledge of what's going on. However, once that case just goes on as it proceeds, obviously they wouldn't be assigned a probation officer or entered into the official admission. The MHDD court monitors defendants' performance and progress through judicial interactions. It's what we call the treatment team staffings. Each of our 5 judges has 2 treatment team staffings per month. Team meetings have to be proactive problem solving. I know that Adam had talked about sometimes things get kind of hairy in there. I do think that that is true at times. We really work on having a team approach. We focus on trainings together. We do things as a team a lot, and that is really helpful, I think, for us. From the judge on down, that we look at each other as a team. So during this treatment team, we obviously discuss our roundtable, the defendant's progress, possible issues, the recognition of their accomplishments too as a team. We come up with recommendations. Obviously, the judge has the final discretion, but our judge definitely feels that they are part of a team. We monitor their progress. The team establishes and reinforces the policies. We strive to provide the defendants with an opportunity to learn and manage their mental illness. And obviously from our team members to learn from each other, because some people are experts in other places. This is our list of our team members. It's much like every other mental health court that you probably see. We have our MHDD court judge, we have myself, we have supervisors from the probation department, our POs. We have 10 mental health POs and 3 DD officers. We have our jail liaisons. We have our county jail mental health specialists. We have our case managers from those agencies that we work closely with. We have our public defender, our public defenders, social workers, and then our prosecutors too. Our prosecutors are mainly a part of the early track. However, if they feel a need or if the judge would like it, they are always welcomed in our treatment team as well. And then obviously, like I said, our typical length is 2 years. For low, moderate intervention in lieu, we typically try to do begin at a 1 year. Their amount of dosage hours that they need, so their amount of the programming is about 100 to 150 for our high risk, and our moderate risk defendants are 200 to 300. I would say the majority of our defendants are high risk or MADs. We have some that are low and low MADs, but not quite as much. And then obviously we phase them through. So here are our 4 phases that they do go through as proceed through the court. Our high risk and our moderate defendants obviously are in court more frequently than our low or our low MADs. Right now we're working really hard on how do we separate out our mental health people and our DD people, because sometimes when a judge hands down any type of response to any behavior, it could be different because mental health and DD people are different. They don't have the same issues all the time. So we're working on how to appropriately divide that. If we want our defendants to learn from each other and the court experience, we have to figure out what's the most appropriate, and that's something we're working really hard on. Obviously, we're also working hard on keeping our low and our low MADs away from our high risk and our moderate people as well. Some of our court benefits is obviously that we work really closely. So we have our treatment team that meets with the judges twice a month, and defendants will nominate or add onto the agenda the defendants that need to go to court. We also have clinical staffing with just our POs and our clinical teams. So each month, each of our 5 agencies comes in, and the POs and the clinical agencies really case plan around each other. We also do that with the County Board of DD. We have regular criminal justice and behavioral health meetings at the Adams Board. We have relationships with our Cleveland Police Department and their CIT officers. St. Vincent's is our ER that we use quite a lot, our crisis unit, and then obviously North Coast, which is our state hospital. We work very closely with our court bailiffs and judges, and we oftentimes are always addressing obviously mental health and linkage, medication compliance, housing are always our #1 things that are very difficult. We're almost done. I just wanted to go over our relationship with our County Board of DD. They have a forensic unit. Our court has a contract with them, and through that they're able to provide us a municipal, a jail and prison liaison, along with a community liaison. They help to early identify them when they are in the criminal justice system and get them relinked. Obviously, because they're team players, they understand our court and our legal system, and they see the issues that are relevant to the individual's disability. Even more so, they are our experts. They are the people who don't know we're not too much for. If the defendant is acting maybe how we expect in court or outside of court or at we utilize their expertise to help us resolve it, and that's really important. Without our behavioral agencies, our liaisons, and our county board people, we wouldn't be able to have the court. We wouldn't be able to serve the capacity that we do. They are vital. They are so important. The relationships with us are very important. In terms of the DD folks, we do have some gaps, and I just wanted to point those out. The defendants that have an eligibility diagnosis may not always be eligible for County Board of DD. And so that's the gap that we're really working on. How do we find services that are appropriate for them, putting them in a COG skills class or an anger management class where there's a lot of reading and there's a lot of comprehension and there's a lot of 3D to dimensional issues going on, can be very difficult for them. And that's a gap that we know exists and we're working on. And obviously, we are looking at future research of how DD folks fare within our specialized courts. There's not a whole lot out there that's telling us, and we want to make sure that we're helping them appropriately. So that's something we're really looking into, and then obviously we want to reduce the number of mentally ill and DD people that are in the county jail. And then this is just a picture of one of our courts, one of our treatment team days. And as you can see, the defendants, our POs, our judges, our bailiffs, our assigned counsel, we are a team. We look at ourselves as a team, and that's really important to us. So I hope I was able to give you a view of MHDD courts that are a little bit different than what you may see out there and the pros and cons that we have with it. Thank you.
Okay, great. Thank you so much, Megan. You can go ahead and get rid of your video if you don't want to have it up. And we're going to now move on to questions. So I think that this presentation provided a good overview of some of the general aspects of mental health court, and then maybe some of the criticisms or concerns to keep in mind, followed lastly by a court that really does address a lot of those concerns in an interesting and unique way, sort of a unique model. And so we've gotten a lot of questions. First of all, if you want the contact information for any of the presenters, their email addresses are on the screen. And we also have them as well at NCCJD if you would prefer to contact us directly, and we can put you in touch with them. We thank them once again. It was a great presentation, and we've got a lot of questions, so I'm going to go ahead and get to them. The first question, and you guys don't have to come back on video to answer these. You can just unmute yourself and feel free to jump in. If they're directed to a specific person, I will let you know. So I guess the first question is for Megan and Jennifer for your individual courts. How are people with IDD assessed or screened for acceptance into the mental health court? Hello?
Was Megan going to answer that one, or do you want me to take it?
Yeah, I can. For us, they are screened typically by our court clinic with a full-scale IQ score. That's where we usually get them. Also, if they are linked with the County Board of DD, they are able to go in and assess them in order to see if they are eligible. So everything's on a clinical assessment, typically through the County Board of DD. Our eligibility for MHDD court is that their full-scale IQ score is 70 or below, and then our court clinic can administer those tests.
Okay, great. Jennifer, do you have anything to add, or should I just?
For Lucie County, what we do for our clients is we don't really have a formal screening process, and we don't have any cutoffs.
Okay.
So it's much more, it's really done by self-report or family report of any concerns of developmental disability, and if there's not a consensus, what will happen is one of my bachelor's level clinicians will go out and assess the case, and they will make the final determination and then make their recommendations to the court. So we don't have any specific cutoffs. We'll take any range.
Great, thank you both. The next question I think is specific for Jennifer, since you mentioned this in your presentation. Is it generally difficult to obtain victim agreement in these cases where you do have a victim?
Generally, no. Once the purpose and scope of mental health courts explained to the victim, a lot of times is what we find is that rather than victims knowing, okay, this person's going to go to jail and then get right out and be back in the same situation, they would rather see us be able to help and implement services to prevent it from happening again. So generally, no, although there are times when it's domestic or family related, where we sometimes have hurt and resentments that will keep people from being able to come in, but generally, no. We don't have a problem getting victim approval to come in.
Great, thank you. Another question, how are these services such as case management, rehab teams, and other services funded? Does the person have to have private insurance? Is it funded through the court, through some sort of grant? How do you guys fund those services?
I am very fortunate. I work in a county that is extremely supportive of mental health court, and they actually have a budget that I work with where the county will actually cover the cost of those services for clients whose either insurance won't cover needed services or if they don't have insurance at all. It's county funded, although we have had some grants in the past. Right now it's all county. Again, my county is incredibly supportive of mental health court.
Great. Megan, did you have anything to add to that?
Sure. Ours is also, I think, much like Jennifer's too, that our county is very supportive. We currently don't have any grants. We have 2 contracts that the court and our county administration has with our Adams board, where they designated one of our mental health agencies that receives the referrals for defendants that don't have insurance, and then our contract with the County Board of DD, we also have that as well. Typically, we work with the Adams Board and the mental health agencies in order to refer out, and many people are covered obviously under Medicaid, and that in the last few years has really helped make and manage our mental health courts a lot easier because we have far less people that are insured now than was prior to that.
Thank you. So the next 2 questions are for Adam specifically. And the first one is, whatever happened to that client that you used as an example in that case? Was he able to be served by mental health court, or what ended up happening with him?
He is actually currently on the streets. We were attempting to get him a guardianship, but the prosecutor, since the judge would not allow him onto the mental health court, Board of DD wasn't willing to take him in for services because they didn't believe they had the adequate services. He's now walking the streets. I hope he's okay.
I hope he's getting any help he can get. The next question for you is, what are some ways that we can help attorneys identify needs that a client might have? Are there any tips that you might have for identifying those needs?
Honestly, that's a great question, and I answered one because I have to leave shortly for court, but I was trying to answer as I went along. But I think the more training that you folks can offer us, and especially defense attorneys who are meeting with these folks at the jail, having these conversations with family members, making these initial observations, and when I when I, in my mind, and this is a very bad word to use, diagnose someone or think someone is incompetent or mentally ill, I'm just using experience. And the more training that I can get, the more training that these attorneys can have, the more likely we are to help these folks. And look, I haven't met an attorney, a defense attorney yet, that if the client needed to be in a mental health court or needed those services from the Board of DD, there is an attorney on the face of the earth that I know of who's not going to go out there and try to do the best they can for their client and get those services in place. But you're absolutely right. We have to be able to identify those things. And the only way that we can identify them is by being trained by the professionals. And you folks are the professionals. We need you so much.
Thanks. So as a follow-up, if an attorney suspects that there is a developmental disability, but they don't have a current diagnosis, can the attorney ask the court to order one for the purpose of referral to the mental health court? And if you can get that order, will the court pay for it?
Yes. There's kind of two answers to that question. Under Ohio law, yes. If you ask for a competency evaluation, a lot of times you can ask for a full psychological evaluation within the competency eval. Under Ohio law, if your client is indigent, the court does have to pay for that. There's also a United States Supreme Court case, Aki versus Oklahoma, which basically provides that if you are in need of an expert and you can show a specific need for that expert, and it can be through your own observations of your client, the court is required to provide you with funds for an expert, whether it is for the purposes of showing a defense, self-defense, or mental diminished capacity, or if it's even in mitigation and sentencing. You want that psychiatrist, that psychologist, you want those diagnoses. I have a case right now where gender dysphoria is something that we're dealing with, and it's something that I'm seeing more and more. And we are going out to the courts and asking them for the funding to actually get some of these diagnoses on the table, so that way the prosecutor's on notice, the judge is on notice. And I got to be honest with you, I'm so impressed with what Cuyahoga County is doing. It is so contrary to what I'm seeing in our rural counties. I would love to see that model brought down into some of the places where I practice. It would be great to see. You guys are doing some great work up there.
Thank you.
Okay. Last question. I just want to ask Adam all of the questions for Adam since he does have to leave within the next couple minutes. I know you did answer this on the chat box, but I wanted to just say it out loud in case people aren't looking at that. Are there any suggestions on how an advocate or family member might approach a court, state's attorney, or public defender when an individual with IDD is facing jail time, sentencing, et cetera, when the individual might be better served by treatment?
From a family member's perspective, it's that much more difficult. When you come to that attorney, if you know that your loved one is suffering from some type of developmental disability, first of all, put that attorney, put that advocate on notice. Try to put the court on notice to the extent that you're able to. Even calling up a victim's advocate and letting the victim's advocate know. I know it's kind of a strange way of doing it, but just getting that information into the court, into the attorney's mind, then you kind of put everybody on notice. The way I answered the question was, if the court will allow you, get diversion. See if you can use a diversionary program. Not every county can do what Cuyahoga County is doing. I wish they would. I think we would serve so many people so much better if we had that framework. But if you can convince a court, if you can convince an attorney, whoever it happens to be, to get that person into treatment on a diversionary basis, it's almost like the concept of intervention in lieu of conviction in Ohio, where if you complete treatment and you're a first-time offender for drugs, we will dismiss the case upon completion of your treatment. It's the same concept, but we're using mental health. And I've seen in some of our smaller rural courts where we have some folks who actually get onto that docket, the courts will take a hold of that. And that's a win for the lawyer. That's a win for the client. That's a win for the court, because you've served that individual. You've put that person in a position to succeed, and you've protected the public. I hope that answers that question.
Yes, it does. Thank you. As an addition to that, I wanted to let our viewers know about the ARC of New Jersey's Criminal Justice Advocacy Program. They have a great program around personalized justice planning, which creates diversionary plans and provides treatment options to present to the court. And you can find out more about them on their website. I will give it to you. Let me find it, make sure I have it right. It is www.thearc.org. Actually, no, that's not it. It's www.cjapnj.org, cjapnj.org, and that is their website if you want to learn more about this personalized justice planning and diversion, and how to get people services if they're not in mental health court, even just on a regular criminal docket. They can provide you some good information there. Adam, I know you probably have to go, and I think that was the last question for you. If there are any more questions that come in for you, I can email you and let you know, and then we can follow up.
Thank you so much. Thank you for the opportunity. Take care.
There are still more questions for the few minutes we have left. We did get a lot of questions. One question, I guess, for both Jennifer and Megan would be, do you screen for one of the accepted developmental disabilities, or do you screen for FASD, fetal alcohol syndrome spectrum disorder, excuse me?
For us, that is not an eligible clinical diagnosis that we accept into our court. Obviously, through that, if they saw that because of that diagnosis that their IQ was lower and it was at our threshold, then they would be allowed in. But I don't believe we have anyone with that as a primary diagnosis.
Okay.
It's similar for me. We don't have anyone with that diagnosis, although I can't say that would specifically exclude them. We would have to see what their current level of functioning is.
Great, thanks. So the next question is, for the jail screening, Megan, that you had said that Cuyahoga County does, how did you accomplish getting this screening system? Was this an initiative by the MHDD court? Was it an initiative by the jail? A partnership between the two, or how did it come about to get that screening system in place?
So that worked. It began through our mental health initiative that began in 2003. The jail was one of the partners in that, and they are a vital role and a vital partner. We work really closely with them, and it can be difficult at times because I think sometimes our goal of keeping people in jail, we never want to, but sometimes we need to in order to facilitate our linkage, so sometimes that can go back and forth. But we worked with the jail, and they were a partner with us in the group. Right now, we're actually kind of going back to our whole pre-trial and looking at kind of our intercept model from the beginning, reviewing it through the Stepping Up initiative to hopefully enhance how we do it and do it even better. And again, we're doing that through a close partnership with the jail. So it's just about relationships and getting everybody on the same page.
Thank you. So you also mentioned this idea of risk assessments, and Jennifer, I don't know if your court does this as well, but how are recidivism risk levels determined? Is mental illness or developmental disability taken into account in the risk analysis, or do you not know?
It is taken into account to some degree in the type of it that it's a responsivity issue. So our state has mandated that every defendant in a court receives a risk assessment, and so Ohio has pushed out the Ohio risk assessment. It was developed by the University of Cincinnati. So in the actual risk score, it doesn't take into account if the person is mentally ill or not. But when you review the score and then you look at the responsivity, that's one of the things that you pay attention to. And if you wanted more on that or on the risk tool that we use, if anyone wants to email me, I could always have you go to that. I can send you the information.
Great, thank you. For your courts, this is, I guess, directed to both Jennifer and Megan, so you can both answer if possible. Are there any offenses that are just disqualifying for the court? And then part two of that question is, does an individual have a choice? If they, for instance, do not want to go to mental health court, do they have that option to opt out if it's recommended that they enter into it?
I can answer for St. Lucie County. There are serious violent offenses that will sometimes exclude people from being in mental health court. And then, yes, if someone does not want to participate, mental health court is voluntary. So they can go back to the original court and be sentenced on their charges, or if they refuse to comply in their condition of probation or pretrial, they would have to face the consequences with that judge.
In regards to us during our early track, all cases can be transferred over to a mental health court judge from a felony 1 to a felony 5. However, that does not guarantee that the defendant would be entered into the official admission of the MHCD court or so the probation end of it. And we are not a voluntary court. If you meet our clinical diagnosis, you are transferred. If a diagnosis is found through pretrial and maybe they weren't transferred right at arraignment, it could technically be at the discretion of that court trial judge with input from the attorney, but more often or not, all of our cases are typically transferred over to the MHCD court because of that continual care aspect, the training of the mental health judges, and their relationships with the behavioral health agencies. We don't mandate that defendants in the mental health court are there every week, like a lot of the other mental health courts. I'm sure there's pros and cons to it, but it's more you come up at the end of each phase and then you come up when there are issues. So our interaction with them could possibly be less than maybe standard mental health court.
Great, thank you. And we do have some more questions, but we are out of time, so I will follow up with each of the presenters for the questions and hopefully be able to answer all of those questions for those individuals. I wanted to let you all know before we leave that our next webinar will be on September 22nd, and it will be on competency and intellectual and developmental disability. So how does this idea of competency within the criminal justice system, competency to stand trial, apply to people with intellectual and developmental disabilities? So you can go ahead and register for that now. We'll also be sending out an email and some more information about it. Secondly, when you leave the webinar, a survey will pop up for you. Please fill out the survey. It really helps us out to have that feedback and that information to move forward. And as usual, if you want to contact us, our contact information is above. This webinar will be posted to our website, hopefully within the next week. And we really appreciate you. It was a great conversation today, and we appreciate all of you being here to listen. And thank you again to our wonderful panel of presenters. And I hope all of you have an excellent day. Thank you.
Thank you.